Oh, wonderful. So all attendees are in listen-only mode. Okay, well, I hope you are listening because we're going to talk about the GDPR for Americans. In other words, how to speak EU. So we can go start off with gross. Bonjour, bon tarde, buenas tardes if you're in that area or wherever you're speaking. If you happen to be in Serbia, it's dobu utro. Okay, so speak it, but how to speak without an accent. You have to, first of all, you have to understand the GDPR, which hopefully you've heard about. And if you haven't, you have not been looking in your inbox, because it's filled with all sorts of brand new privacy notices that are supposed to comply with the GDPR, but in my view, don't. Anyway, so off we go. Here we go. Introduction. I am William Gamble. I work for IT Governance, who's putting on this seminar. I've been a lawyer for longer than most of you have been alive. I practice probably every area of U.S. Regulatory law, including tax and securities law. And in addition to that, for IT services, I love cybersecurity. And I'm the author of 3 books. Most of it had to do on law and economics and the regulatory environments in China and other emerging markets. And they, of course, are available on Amazon.com if you feel the need. I work for IT Governance, and IT Governance is a one-stop shop. The GR for governance, for GRC, Governance Risk and Management Compliance. And we do cyber resilience. I also teach and audit ISO 27001 and that wonderful family of ISO, if you're not familiar with it, being Americans, that stands for International Standards Organization. And that's what the rest of the world does. And we also do governance and management, risk management, including a number of other ISO standards. My favorite is the up-and-coming ISO 37000, which is the corruption standard who are interested in the Foreign Corrupt Practices Act, which I may speak about later or not. It all depends. Okay, now, what I'm going to talk about today is why organizations, especially American organizations, have to comply with this damn European law. We're going to talk just a bit about how the General Data Protection works. We're going to talk about what a data subject is. And it is an EU citizen, as you probably think, but it can be much, much more. We'll talk about breach notifications. If you think it's just limited to GDPR, you are wrong. And we'll talk about those terrible international data transfer problems, which I'm sure if you have any relationship to Europe at all, in terms of transferring data or information, that is definitely something you should pay attention to. Whoop. That's called something going back in time. I thought I was the only one who did that. Okay, the first is why the GDPR. First of all, it may become news to most Americans, but the GDPR was not created last Friday. It didn't go effect last Friday. It wasn't created 2 years ago in April 2016. When was it created? It was created in 1995, way back in the last century, during my century. Now, why was it created what happened in 1995? Well, the European Parliament created the Data Protection Directive, or the DPD. Now, this one is called the General Data Protection Regulation. What's the difference? The difference between a directive and a regulation has to do with all the member states. There are 28 member states in the European Union, and under a directive, they don't have to follow the directive exactly. Basically, it's a guideline. Now, if they want to come on board, which they have to pass their own laws. All right, so basically you had 28 different laws which were similar to the Data Protection Directive, but they had a whole lot of differences. For example, the Germans had far more supervisors, far more regulators than most of other countries. Most other countries have just one regulator. Now, the problem with that from the Europeans, the other thing about the DPD was that the fines weren't big. So if you remember Rodney Dangerfield, the DPD was not getting no respect. So what happened in order to ensure rapid transfer in the European Union of data, what they did is they said, okay, let's have one regulatory framework. So they said, all right, we'll create the General Data Protection Regulation, and the GDPR basically is the same or will be the same in every member state. Now there are 4 states that have passed to GDPR, and that means that there are another 24 states that have done nothing. Now, if you don't do anything, basically your country swallows the GDPR whole. And if you pass laws, and actually Germany's and Austria's are more restrictive than the GDPR, you are probably getting a lawsuit. But why do we have these things anyway? Why bother with data protection? I mean, isn't it good that all these wonderful entrepreneurs are out there using our data, technological advances? Like maybe I can find my girlfriend on the next block. I mean, isn't that what we want actually? Well, the Europeans see it a little differently, basically because of their history. Now, I always ask my delegates when I teach this subject matter, which I do on basically a regular basis, at least monthly, and I always ask them a question about history. Okay, now let's put on your history thinking caps on, and I'll ask you a question: how many have you ever heard of the Stasi? Not many, as usual. In other words, usually I get, if I'm lucky, in 10 or 20 delegates, I usually get 1 if I'm lucky. If I say Gestapo, I get tons of hands. Also, if you remember, 1995, half of it controlled by the Soviet Union. Now, as I'm sure all of you remember who actually go to the movies occasionally, the Soviet Union had a secret police, and the secret police used to spy on people, and the German secret police was called the Stasi. And when the Berlin Wall fell in the middle of the 1990s, they opened the Stasi files, and guess what they found? They found that 1 out of every 3, 1/3 of the population were informants for the Stasi. They were informing on everybody. So your employer, your child, your spouse, your friends, everybody was potentially informing on you. So the Europeans with that history are very, very sensitive to information: who uses it, who gets it, what you do with it, how long you keep it. So it's not a joke for them. This is exceptionally serious. Now, what is the GDPR about? You may have heard that the GDPR is about cybersecurity and privacy. Well, that is definitely true. And what they have, or which we will get to in a moment, are the principles. And one of the main principles is that you have to have. The other thing that you have to have is privacy. But more importantly, and this is the most disruptive that I have probably seen in 40 years, is that it describes something else. Your property rights in your data. Now think about that. We're property rights. Right now, for example, let's say I had a car. Right now, Google can take that car, they can drive it away, they can use it as long as they want to, they can sell it, they can damage it and bring it back. They don't have to pay me for it. They just say, well, okay, we're going to use your car, or Facebook can say, we're going to use your car because we're giving you all these wonderful things for you. We're giving you search engine and the right to talk to your friends and all sorts of great things. And all we're taking from you is your car, and we're using it any way we want to. Okay, that's the present situation with data. They're basically using data any way they want to. Now the GDPR says, oh no, we're not going to do that anymore. What we're going to do is we're specifically going to say that we're going to define basically how your property rights in data, what those rights are. And the GDPR is very specific about that. And it basically is very disruptive because it changes a whole lot of business models, which are based on the concept that you can use somebody else's data anytime you want. Okay. Now, but that has to do with Europeans. Europeans got all those great laws. Well, but how does that affect us, more importantly? Because we're in the good old USA. Well, why do we care about this type of thing? Well, first of all, a lot of the elements of the GDPR exist right now at this moment in the United States. Let's start with breach notification. Alabama became the 50th state to require breach notifications. In addition, there's state laws. There's a whole bunch of, there's about 10 states, maybe about 8, that have laws governing cybersecurity specifically. Like in Massachusetts, there are very specific laws about what sort of cybersecurity you have to have. In addition, there's a whole bunch of sector laws. There are a whole bunch there are a bunch of sector laws which you might be familiar. You've probably heard of HIPAA. You might know about the finance laws, like, for example, all the people in New York have to comply with NYDFS, which stands for New York Department of Financial Services. Or you might have heard about insider trading or failure to notify people of a material piece of information. Now, Yahoo had a breach in 2014, and they failed to made timely notification of that breach, which would affect the interest of any investor. As a result, they got fined $35 million by the SEC. So a lot of the fines that you will see in the US are actually far larger than anything that the Europeans might put against you. The GDPR also is the de facto global transfer, basically because the transfer prohibitions. Now, if you are a trading country like, say, South Korea, and you trade with the 3 main blocks, and one of them has a restriction on data, which regulatory framework are you going to comply with? If the other 2 don't require anything, you don't care. But if one requires something, you're going to make sure your laws correspond with the stricter framework. So a lot of countries like Qatar and Korea are basically swallowing the GDPR whole. In fact, as we get further on, I'll tell you a little about the Singapore law, which just had a very interesting decision. The other reason, obviously, you want good sophistication, because the criminal organizations in cybersecurity are very sophisticated. More importantly, it's not about the fines, it's not about the regulation, it's about your brand. In a recent poll in England, 80% of the people polled said if you did not have good privacy and security, they would find someone else. So in order to be competitive, you're going to have to clean up your act and make sure you protect both security and privacy for your company or whatever your product is. Again, the other big thing is what I'm seeing a lot is that we're seeing a lot of supply chain people. It's like, we don't want to do business with a vendor who doesn't protect our data, because we have to protect our data up and down our supply chain. And if you don't protect it, the privacy and security of your data, we just don't want to do business with you. So of course, I already talked about the SEC, and then in the United States, you might have heard of a certain wrestler by the name of Hulk Hogan, whose real name is Bolia, who sued Gawker and got $14 million. Did that have anything to do with the GDPR? No, that's good old American law, and he's sued under the right to privacy. The other problem is if you get sued at all, most likely it'll be negligence, and you will have to make sure that you are up to the standard of care, and the standard of care obviously is getting higher, and that is what's going to be required. Also, take a quick look at this slide, which has all the regulatory agencies in the United States. Actually, there could be more that I can think of that have cybersecurity regulations. The one area I don't see on there right offhand is the FDA, the Food and Drug Administration. Why does the Food and Drug Administration need cyber? Have you ever heard of the Internet of Things or all the type of ultrasounds or other machines that are either run by or connected to the Internet? In fact, that's one of the more interesting and new pathways. They go through your MRI or ultrasound machines in order to get to the hospital database. So the regulations here include over 10 or even more federal and state regulatory agents that are regulating both privacy and cybersecurity. So it ain't just the GDPR. Okay, now we're going to talk about the various standards. Part of the EU is basically they encourage that you have certain standards of cybersecurity. Now, one of the standards they almost de facto require is the ISO 27001 standard. If you're not familiar with ISO 27000, it is the ISO standard for cybersecurity. Now, in the United States, we have our friends at the American Institute of CPAs basically came up with a type of certification. It's not even a certification, it's a letter that says, okay, your IT systems comply with Sarbanes-Oxley, which is mandatory for public companies. So they came up with that. But the problem with that is it's a lot different. It's a lot different from the ISO 27000. The reason is because ISO 27000 is a management system. It is not more or less a checklist like COBIT 5. And that is basically what the EU standard is working its way for, is for an entire system that you don't just tack on privacy, that you build it in from the beginning, which is also, by the way, part of it. We get that mostly from the Canadians, and so that's part of their privacy framework. By the way, there is a difference between the way that Europeans regulate, the difference between the way the Europeans regulate and the way United States regulates. And what they can do is in the Europe, they have fines, reputation, and operational different types of things that can impact you. One of the things the supervisory authority is not just give you fines, they can also, they have injunctive powers. So they can basically stop you from doing something. Now that might in some ways be worse than a fine. If you consider what happened to AWS, if it could no longer transfer information across the Atlantic, that might be a difference. In contrast to just the fines, I want to make it very clear that what we're doing as part of the compliance with cybersecurity and privacy is basically to improve the operations of your business. It's not necessarily about just the fines or something like that. It's about your brand. It's about making your business more competitive. It's about making your business more efficient. All right, let's talk about how the EU and the GDPR got into the extraterritoriality business. You might also consider how the US got into the extraterritorial business if you ever consider the Foreign Corrupt Practices Act, which started to be enforced in 2005 against mostly European companies for huge fines, many in the billions of dollars. But as to the GDPR, that covers not just EU citizens. In fact, I work, as I said earlier, for IT governance. Now, what does that give me? Hopefully, besides a paycheck, that gives me the rights of a data subject. Why? Because IT governance is located in Ely, UK, which for the present moment is part of the EU. So since the controller or the people who can process my information are in the EU, then I have the rights of an EU citizen, at least as in regard to my data held by my employer. Also, it's not just EU citizens. Also, if I happen to be in the EU, if I'm in the EU and if I'm in France and I killed somebody in France, I'll get tried by French law. So, but if I'm in France, I also get all the rights of other French people in regard to my data. It also does not apply simply to EU businesses. Let's take, for example, the Cerro Largo Hotel in Kissimmee, Florida. Now, if its website is in English and all it takes is deposits in dollars, and if a EU citizen happens to sign up and go to that hotel, the hotel does not have to comply with the GDPR because it's not doing anything in Europe. However, if its website, say, is in German and it takes EU and it takes euros for deposits, then the GDPR considers that it is doing business in Europe. So they basically say that the hotel in Kissimmee, Florida, since it's trying to attract selling to EU citizens, it should comply with EU law. Okay, now you have to remember that the EU regulators are a little different from American regulators. If you look in the tax code, which I've looked in for far too long, it would be difficult, if not impossible, to find any provisions that would mitigate the effect of the regulation. You either owe the tax or you don't owe the tax, and there is no ifs, ands, buts about it. Now, you might be able to extend payment for a while, but they still want you to pay the tax. Now, the European regulators are quite different. Now, if you look at the punishment section, which is Article 83, and that's the horrible 4% and 20 million euro fine, the reason you're taking this course is you will see not just the fines, but another thing, that's something very interesting. You will see 11 mitigation factors. So the probability, unless your name is Mark Zuckerberg or you are Facebook, the probability of you getting fined is actually rather small. What may happen to you is they will look at your record. And basically they want to figure out how much did you lose? Did you lose a couple hundred names? Was that intentional, or did just somebody make a mistake? Is somebody else at fault? Have you done this previously? Are you cooperating with the regulators? What sort of categories of data did you breach? Did you breach information, just the name and email address, or did you release sensitive financial information or sensitive healthcare information? And also quickly, how did you report the breach? Did you report it immediately? How are you trying? Are you really trying for cybersecurity? Have you done a certification like ISO 27001? Now, if you let's run down the same list and compare it to an American company. Like, for example, let's take Equifax, the nature and gravity and duration of the infringement. The Equifax infringement went on for a couple months. The mitigation, the Equifax, they really didn't even try to mitigate it. They were probably hacked in June and didn't really do anything about it until July, as I understand it. Any previous infringements? I'm not sure about that. Did they try to cooperate? Well, not really at all. Categories of personal data. Equifax lost very sensitive financial data. Did they report the breach? No, they didn't. So, and I believe they might have been certified. So the problem is that these people would probably be subject to a larger fine because basically they're not trying. What the point is the American the European regulators, unlike many of their American counterparts, are more interested in making sure that you have cybersecurity rather than slapping a fine on you. Will they slap a fine? Oh yeah. When? I would say in a couple of months. But for the rest of you who are actually trying to get your ducks in order, trying to protect privacy, trying to protect people's information, the usual thing you will get from a regulator will be an advisory about how to clean up your act. Now, that said, the main areas that you have to worry about are the principles, the 6 privacy principles, the 8 rights, and the transfers. If you get those things right, if you protect people's principles and rights, and that you make sure that the transfers are subject to one of the exceptions, you will almost absolutely, with certainty, avoid the 20 million fine. However, if, like many certain organizations that have been in the news recently, your business model is based on the violation of those principles and rights, then you're almost guaranteed to have that big fine. Now, I did a speech about a year ago for an OWASP society, which was basically, I called it advanced legal threat vectors. And these are the attack vectors basically for the GDPR. Your big one is, of course, the data breach. You violated cybersecurity. Well, the point is about that, you're going to have the same issue. Yes, that will get you a fine under the GDPR, but it would also get you a fine if you don't handle it properly under the 50 state laws. It would get you a fine under the SEC if you didn't report it correctly. It will get you a fine during a HIPAA, NYDFS, as well as get the scrutiny of the supervisory authorities in Europe. So the main issue with the GDPR is addressing, which doesn't really change between the US and the EU. The only major difference in the EU is the EU law is consistent across all member states. The problem in the United States is we have 50 or it depends on what sector you're in and whether you're a public company or healthcare or defense or finance, you have 50 or more different state laws or laws to comply with. So the mess in the United States pales to the uniformity within the GDPR. The addition is in the GDPR. The other thing that you have to worry about in the GDPR are your subject access requests. What are they? Article 15, they basically are those nasty little things that allow people like you and me to find out what information a company has on us. For example, I recently got a notice from Credit Karma, and it said that my email, which I knew had been breached in 2005, was lost. It was lost because of 6 companies had been breached, and they lost my email. My problem with the notice is I'd never heard of those 6 companies. I had no idea how those 6 companies even got my email, and then they got it from somewhere, God knows, and then they lost it. Now, the data subject access request is the request by the data subject to say, what information of mine do you have? What are you doing with it? Where did you get it? That type of question. Reasonable questions that anybody would want to know about their data. The problem is if you don't respond to the subject access request, it's like a data breach. The authority and the regulators will be quite interested in you. So the 2 ways to best protect yourself against any supervision, any problems with the European regulators is to make sure your subject access request procedures are robust. And if you want to protect yourself from all regulators, make sure you have good cybersecurity. And it doesn't matter whether or not you do anything in Europe at all. Okay, let's talk about, remember we had principles and we also had those pesky things called rights. Basically, they call them rights and principles, but basically they're all rights. The difference between the principles and the rights is basically all the rights are absolute. Now, let's look at all 3 of them. Now I call them, the first one's lawfully, the second is legitimate, adequate, accurate, restored, retention, and the last one, big one, says, thou shalt protect property. Thou shalt protect the data of people because it don't belong to you. Now let's look at the first principle is lawful. Now, if someone takes my car, hopefully they're not. If they do it unlawfully, that's grand theft auto. Well, the GDPR basically says the same. Your data is that you should make sure that if you take someone's data that it is only lawful. That you only take it lawfully. The second issue is you can only get data for a specific purpose or legitimate. Now, what does that mean? Well, that means that if you're going to use my property, you have to tell me exactly what what you're going to use it for. You can't, if you say you're going to use it for one such type of thing, you can't use it for another. Now, in fact, Facebook got taken to the carpet and fined by the Federal Trade Commission for inaccurately stating what data was basically, what they were using data, what they were taking it for, and what they were using for. Adequate. That basically means you shouldn't take information you don't need. If you don't need my birth date because I'm just buying, a toothbrush, then there's no reason for you to take it. Just, absolutely you need in order to do whatever you have to do. Accurate. You have to make sure that if you take my data, that you keep it up to date. Now, this is actually not this is actually a very reasonable thing to have. You would definitely want to have this type of point. If you've ever looked at your credit report and if ever you've tried to correct your credit report, you can understand the frustration with the fact that you don't really have much of a right to tell people, to tell them that your data is inaccurate. It takes you, a long time to prove to them, to prove to anybody like the credit reporting agencies that wherever they got their data from is absolutely insane. Is that you are the best person to understand whether your data is accurate or inaccurate. All you want is the right to make sure it's accurate. Also, retention, stored for only as long as necessary. If you don't need the information, why are you keeping this information on me forever? And you might have started looking at your privacy notice and you might have gotten notices from people you haven't spoke to in years. Why are they still keeping your information? I mean, when you think about it, it's absolutely insane. They're keeping your property for basically forever for God knows what reason. And it's rather silly that they're using your stuff when they don't even need it. Finally, is the process in a matter of security. So you want to make sure that your security and that you are protecting other people's property. If it's not yours, if it's their data, they certainly don't want it lost. They don't want it, hacked. They don't want to put it on the dark web. They want to make sure it's safe. And that's part of your job, not only under the GDPR, but also under US law. Okay, now, lawfulness or basis of processing. This is an example. We're going into, first of all, remember the first principle was lawful. Okay, when we talk about a lawful basis for property, that's the first principle in terms of the 6 principles. People have put enormous amounts of effort in terms of lawful basis for property. That one principle, you have to remember there are 5 others. All right. However, the GDPR says specifically, because remember, it's defining a property right, it says specifically that there are 6 lawful bases for processing. Now, everybody has obsessed about consent, but consent is just one of the 6. And basically, of the 6, you can really use 4. The really good one that most people will use, or what you want to try to use, lawful basis, is contract. If you have a contract with somebody, then you have a lawful basis for processing their information. You have to look, you have to have that information to process it. The difference between the consent and the other basis is if the Lord giveth, the Lord taketh away. So if you give consent, you also can remove consent at any time. That's not true of contract. Once you have a contract with somebody, you have a lawful basis for processing your information. It's like property. If I have a contract to loan you my car, then that's a lawful basis. If you have a contract to process information, you have a lawful basis for processing my information. The other one, of course, is a legal obligation. If the government imposes an obligation on you to use to process information like a W-2, or in Europe it would be like a national ID number, then you would have a legal obligation. The government, you have the right to process information because the government tells you to. And the sleeper here is legitimate interest, which a lot of people have been whining, how can we do direct marketing? Well, it's a legitimate interest. So that is one of the legitimate interests. The main thing is when you do all these things, you have to be sure that you're doing it in a manner that's fair, open, and transparent. Don't put things on page 32. Like if you look at the most recent privacy notices you're getting in the mail, you're getting stuff that is basically hidden somewhere. Okay, one of the biggest principles here is principle 6. Now, the reason that is important is this is the cybersecurity, which of course is required under many statutes in the United States. And of course, you don't want it. The real reason you want securities is because basically your business, all businesses, whatever they are, their central process is information. It's not ancillary to your business, it is your business. If you cannot protect your business's information, no matter where you are, you're going to be out of business. So security is one of the major issues, not only with GDPR, but everywhere. Differences of the GDPR is that it makes a very simple point, is your security doesn't have to be the same for everything. If the only information you have are emails and like names and phone numbers, you don't have to keep massive amounts of information. If you've got healthcare information, you have to, but that really depends on your risk assessment. Now, there's also special information, not sensitive information, special categories of information, and they're very similar to things in the United States. In the United States, we have EPH high under HIPAA. That's private healthcare information. In Europe, they have special categories under Article 9, and those include stuff that for historical reasons you can guess at. Race, ethnic, union membership, genetics, biometrics, which is biometrics is part of Illinois law these days, health, sex life, and sexual orientation. Okay, then there are the rights. Okay, there are 8 rights in addition to the principles. There are the right to be informed. Well, how do you comply with that? Well, you give them a privacy notice. What sort of privacy notice it is, they say so, but is it going to be 49 pages? No. What it should be is 1 page with links and anchor to other things. So what is it? Oh my God, it's easy to read. Is this, an issue is this something that is terrible? No, it's not terrible. It's just making sure that you're saying what you do and do what you say. It's not fake news, people. Okay, the right to access, that's your subject access request. Who wouldn't want the right to access? You do want to see what stuff you have. Right to rectification. Again, go look at your credit report and try to rectify that. Wouldn't you want to have this type of thing? It's a reasonable thing to have. The right to erasure and lawfulness. Now, that's the right to be forgotten, which might be controversial, but again, it's a right, so it doesn't apply in all situations. The right to restrict processing. Well, that usually pops up if whoever's got your information is doing something wrong, you have the right to stop it. The right to data portability. Well, that's all about free markets. You want to be able to move your data around or choose your vendors without any problem. It's like being able to switch your cell phone number between vendors. Jack, if you're not using the information properly, you should get the right to object. And then one of my favorites, the right to avoid an automated decision making. Rather than getting your credit request or your mortgage or something else based on some algorithm, you have the right to actually talk to a person. Isn't that an exciting concept? Anyway, privacy notices. That's where the right to be informed. Again, say what you do what you say. Don't, have some little tricky thing or say, we're going to sell you all these wonderful things. If you tell people what you're doing with their information, it's their information after all. Wouldn't you want to know what they're doing with the information? So you have to tell them if they're direct marketing. You have to tell them if they didn't get it, where did you get it? Where did those 6 companies who lost my email address get the information? This is also true in the US because we have under the Federal Trade Commission, Federal Trade Act, which has been around since 1905, you have unfair and deceptive practices. both Google and Facebook signed decrees with the FTC because they were saying one thing and doing another. Okay, now how do you exercise their rights? Now, in the United States, there are 50 breach notifications, but only 17 of those states actually give you what's called a right of private action. Now, a right of private action allows a citizen the right to enforce a law. Whoa, there's a new concept. And now, however, under the GDPR, they are very serious about this. What the Europeans want to do is give EU citizens specific rights to be able to actively protect their data. All right? So you have all sorts of various ways to exercise that. One of the ways is to ask for it. See who's got your data, what are they doing with it? You might want to be able to erase that data. That also exists in New York and California. You might want to rectify your data, and that would be something that you would that like a credit history. And then of course there's portability, objection, and profiling. Now the dramatis personae under the GDPR come down to two types of people. They're controllers and processors. Basically, you don't want to be a controller, because as you see from the little chart down here, is the arrows go between the individual. You know, it's their data. They're giving the data controller the right to use their data, but they have the data controller has all sorts of duties. Now you notice the line does not go this far. It doesn't go to the data processor. The difference between the data controller and data processor is that the data processor only has to do what the data controller says. The data subject can sue both, but they can only ask for their rights from the data controller. There is joint and several liability. What's important in this thing is that you have your contract, a strong contract between the processor and controller. And there's actually a template, it's called the Slalom Project, and the list of various types of things is found in GDPR Article 28. Now, this is exceptionally important. The GDPR uses the word document or documented 22 times. And as the thing on the slide says, if you don't document, you didn't do it. I got that from nurses. But this is not just limited to the GDPR. I was reading a legal article from where else? Singapore. And Singapore has had a Privacy Act since 2012. And they recently had an opinion, and they basically said, while an organization may have data protection policies and practices in place, it is equally pertinent that these policies be clearly documented. If an organization's policies and practices are not clearly documented, it is simply corporate practice, IT tradition, and it will be inevitably difficult to demonstrate. So it's very important to be able to demonstrate and basically show that you're actually protecting people's data information. The heart of the GDPR also basically is a data inventory. One way to make sure you have a data inventory and to find out where your data is going is to utilize a data map. The great thing about a data map is it tells you what information you have, and that helps you totally it makes it much, much easier to comply with the GDPR, and it'll make much, much easier to comply with all the regulations in the US as well. Now, the other real problem is the transfers of data outside the EEA, which stands for European Economic Association. Now, as you remember, I said there were 3 areas under Article 83, violation of the principles and rights. And the last one is transfers. Transfers outside of the EEA are prohibited. No, can't do. What your point is, unless you come within one of those exceptions. Adequacy, there has to be an agreement between the European Union and other countries to prove that they have laws that protect data of their citizens and the EU citizens. And there's about 10 of them. And the big ones are, if we exclude the Jersey Islands and Andorra, you basically have Canada, New Zealand, Argentina, Uruguay, and Israel. But the whole point of adequacy, it again, is that's the reason why the GDPR will become the international standard. Because if you're going to go into data privacy, you're going to take the standard that is the highest. The other exceptions are standard contract clauses. That's the easiest one to do. The binding corporate rules are for a corporate group. Privacy Shield is an agreement that it will probably be, which may not survive another 3 months, but it's there. And then there's a funky one called consent, which may not work, but it's if you agree to allow your data be moved out, then it's okay. Now, enforcement, the Europeans are very serious about this. They give 3 methods to enforce these actions. You can go to the supervisory authority and complain about somebody not giving you a right. If the supervisory authority doesn't, is too slow, you can get a court to order them. That'd be pretty cool. I mean, I can get a state attorney general to enforce my rights, or I can sue the company directly. So there's basically a right of private action. Now, this might be a problem. The only reason you shouldn't worry about this so much in Europe is because they don't have contingency fees, and for right now, they do not have any class action suits, although that may change soon. Now, most American companies have basically fallen to the very similar problems, but most of them are really not large, because this is nothing to be afraid of. Most American companies, their problems are providing the rights under the GDPRs to their European employees. They might have EU retail customers. They all have European B2B contacts, which are data subjects. Yes, Gerhard Schroeder and Mannheim Widget Company is a data subject. Sometimes they have partners. And those are the main areas that partners who demand that their procedures and policies comply with the GDPR. Those are the main areas that U.S. companies have to comply with. But complying is actually pretty easy. All you have to do is you have to get your policies and procedures for your subject access requests so you can respond in 30 days. You should have brief procedures, but you need those anyway. And you should have privacy notice, and you've seen a lot of that lately. And you have to have your standard contract clauses basically for your transfers. If you do those 4 things, you basically have gone a long way to make sure that you're complying with the GDPR. So how to establish? What you do is establish an accounting governance framework. The best thing you can do is conduct a data audit. And then the other things you can do is develop procedures. That you can develop policy and procedures, which you probably should do anyway, especially for breach. That's absolutely necessary in the United States and everywhere. And the other thing to remember, 95% of the attacks are through people. Professional hackers attack people, not technology. So what the most important thing you do, if you have any information, and that's everybody, is to make sure your staff is trained. And not only in, the only difference with the GDPR is you have to make sure they're trained not only in cybersecurity, but also in privacy. And then the next thing is that if you don't audit it, it's not going to happen. So make sure that your entire system, that your data is protected, not just for the GDPR, but for your customers and for your business at whole. Then you have to make sure that you monitor and audit. Okay, now, if you're more interested in IT governance and next step, if you want to know more, feel free to contact us for other types of things like courses and books. The Privacy Guide is a short and dirty, and it's excellent. Or come in and find out exactly what you're doing wrong. It's a gap analysis. Okay. I have finished with 5 minutes over, but nevertheless within times, and I'm more than happy to answer questions, assuming I can get any of this thing to work. So if any of you want to send questions or have questions or want to type them in or chat or whatever you need to do, if you're still there, feel free to include them. Okay, good. I'm so excellent. I've answered all your questions without even. So one of the things, to bring you up to date with other things, you also might have noticed that in cybersecurity and privacy law, the law changes how long do you have to respond to a subject access request? 30 days. Now, the problem with that is you have to make sure you respond, is making sure you know when you got it. So you have to have strong policies and procedures to make sure that you log in when you actually received the request. How long do you have to respond to the right to be forgotten? Well, the right to be forgotten, it all depends. That depends on your subject access request. So you have 30 days to respond to that. The right to be forgotten doesn't exist in every situation. It only exists in very specific situations. So basically, you have 30 days to respond to the subject access request, but the subject access request may not have the right to be forgotten in there. But you have to respond to that and decide whether or not in a specific case that they actually do have that right. Okay, how do you prove that you've forgotten the? Well, that's a good question. To actually prove these things would be probably exceptionally difficult and would probably take a lawsuit. I mean, let's say, for example, you ask me to give you back all your information. Well, how do you know that I've given you back all your information? Well, you don't really know unless you do discovery under Rule 27 of the Federal Rules of Procedure would allow you to go in discovery, and then you have to swear that you've given it all back. You will get a link to these slides. And how do you reckon deletion of record and comply with the GDPR? Well, the problem I'm seeing with my clients, how do you recommend to do a deletion of a record? Is often how they store their information, because the nightmare I keep seeing, fear in the IT department's eyes when they say, well, do we have to delete everything from the tapes? And so the reality is probably not. The question is, why do you have the tapes anyway? In one of my classes, we had a wonderful gentleman who pointed out that Iron Mountain, basically of all the stuff paper that gets stored in Iron Mountain's vault, only 10% ever gets requested. So the question you have to think about, and one of the wonderful things about the GDPR is it's going to force you to think about this, is why do you keep that? Why are you asking these questions anyway? And why do you keep this information? It's costing you money. So, why are you just wasting money on information you don't need, you don't want? It's just put in your privacy notice, we're going to keep your information for as long as the law requires, which is usually statute of limitations. And so let's say it's a contract, we'll keep it for 3 years. You don't contact us for 3 years, it goes bye-bye. This is going to be a huge boon for the SSD, the storage product, because it's going to make the access to this information, much more. The easier you can access and the quicker you can delete it, the better. Now, I'm not sure exactly what software you're using to delete a record. What proportion of U.S. companies doing business with EU citizens do you think are already compliant with GDPR? I love that question. Well, those who think they are compliant with the GDPR is something like 80%, or something like 95%. But the last statistic I saw, only half of those had even come up with a budget for compliance with the GDPR. So the reality is of those who have actually done anything, it's probably a lot less. Another statistic I saw on a global basis is there were 30% of the firms internationally hadn't even heard of the GDPR. So now, is everybody compliant? Hell no. Are the Europeans remember, the GDPR responds to everybody, not just companies, but everybody, including the government. And the governments have admitted that they're not totally compliant. So, and you might have noticed that on last Friday, nobody turned into a fraud. Nobody was fined billions of dollars. Oh, do we need? Yes, but we need to comply, not necessarily because the law tells us to comply, but because simply it's a good business. And I think is that the last question I got? Yes, thank God. If there's any other, I don't see any other questions I know of. So, and it's my time is almost up. I will sign off here, and I would like to thank you very much for your time and your interest in this area. And if you need any more information, feel free to contact us. And thank you very, very much for listening. And have a lovely day.